Today I'm with Greg Jemmeson from Jemmeson Fisher Solicitors and Accountants. Good afternoon, Greg.
Afternoon, Brian.
Well, our subject is a very interesting one. When fair trading come knocking at your door, a fair trading inspection. A couple of questions first of all, if I may. A lot of agents want to know what rights fair trading have of entry, and can they ask for them to come back and make an appointment?
Quite a simple thing here is under the Property Stock and Business Agents Act, an agent has to have their records at their registered place of business, okay, their trust records for the last 3 years, and that includes sales files, property management files, etc. Now, under the legislation, authorised officers from fair trading have the right to inspect records during reasonable business hours. Now, that can be taken as Monday to Friday, 9 till 5. There is no requirement for fair trading to make an appointment. They can just turn up at your office. And if you're the licensee in charge and you're absent, fair trading have the right to have any other employee or agent who's in the office who has apparent control of the records provide those records for them.
So you don't have a choice, do you?
Essentially, no. The minute you decide that you want to have an occupational licence under the Property Stock and Business Agents Act means that you have to comply with having your records available. Now, if you choose to say, no, it's inconvenient to me today, well, it's never convenient for fair trading to come knocking. They can put you to great inconvenience. They can issue you with a written notice requiring you to bring all records to their office. So they can cause major disruption to your business. So essentially, the only tip I can give you is when they come, be civil, treat them like they're your #1 listing, provide them with the records and that they want. Don't argue with them. They're human as well. Just don't get them offside and try and comply as much as possible.
So they walk into your office and they say, I'm from fair trading. The first thing that they should do is show you identification.
They should, yes.
And if you would ask for that if they haven't?
You can, you can. Mind you, I'm not quite sure who'd want to come and look at your trust records if they weren't fair trading, but still.
True, okay. And at the moment, they're doing random audits.
Yes.
And they seem to be wanting to enforce the underquoting guidelines.
Yes.
And so they're picking about 3 or 4 properties out of your window or off your website, and they're asking for those files straight away. What would they be looking for once they get to those files?
What matters I'm seeing at the moment is that firstly, you have a compliant agency agreement. I notice they've been issuing penalty notices for people who have undated agency agreements, an unsigned agency agreement. They're looking to see that the agent's estimate is within the 10th percentile band.
We had one agent ring us the other day about that. They wrote 950 to 1,050,000. Now they got fined because it should have been 950 to 1,045,000. It's that prescriptive, agreed?
Yes.
Yep.
And you don't have a defence. They'll want to see that there's some substantiation. They want to see generally at least 3 comparables, okay? If you haven't got 3 comparables, you need to have some written reason in your file as to why you've come up with this specific price.
And how.
And how, yes. Another interesting area that I found a number of agents have been fined for, an $1,100 on-the-spot fine, is under the fraud prevention guidelines, which falls under the regulations and supervision, is not having a form setting out how they've identified who the vendor is. Okay, so I'd hazard to guess that the vast majority of agents don't have any form of that nature. One of the interesting things about this vendor identification is the legislation does not say if you know this vendor, you may have known them for 10 years, they may be a personal friend, there's still a requirement to fill in the identification form and keep it on the file.
So as they're going through your files, if they would look at all offers that you've received and handed to the owner in writing and how you've done that. And one of the things we're hearing back is that they're suggesting that you need to have the vendor's response on file.
That doesn't appear in the legislation. It would be nice for an agent to have a paper trail and receive an email back from the vendor saying, I accept that offer or I reject that offer and why. And it may be good business practice, but it's not an actual legislative requirement.
Okay, so then once you've given the offer to the owner, depending on the response that you have, as we've done in previous videos, they're looking that you have moved your quoting or moved your pricing if that offer has been rejected.
Yes.
They're looking for that?
Yes.
Okay, and they're also looking for that if you are moving your estimate as you're receiving these offers and as you go along a marketing campaign.
Certainly, like we've talked about before, where the agents come up with an opinion of $1 million to 1.1. As a result, the marketplace is saying 9 to 950 based on maybe some unapproved building work. And they want to see that the agent has written to their vendor and said, I have changed my opinion 9 to 950 based on the unapproved building work which we weren't aware of when we did the initial inspection of your property.
And they are looking for the agent to be changing their estimate as they go along.
As they go along.
It's important that they do that.
So a classic example would be in this particular case where we're recording the price. So when we've got our open home inspections, we've put on the top 1 to 1.1 is the price we're giving to people. This is the date. These are the people who came through. Next, 2 weeks later, we've now got 9 to 950 on, because that's what we're now quoting, but there's some evidence on the file that we've written to our vendor and explained why we've reduced that price to 9 to 950.
It really is all about having your paperwork right, isn't it?
Very much so.
If you don't have your paperwork right, expect to be fined. If you do get an on-spot fine and you disagree with it.
There are a number of things you can do. You can write submissions to Fair Trading, plead your case. I don't know of many agents who have done this yet and whether they would be successful. I've obviously had a number of calls from people where they've explained what's happened, and unfortunately, if they've got the 10 percentile and made it 20% in the agent's estimate, there's no defence. Unfortunately for them, they can go to NCAT to have the matter heard as an administrative appeal. However, unfortunately for the agent, the cost of running an application like that may well outweigh the benefit of having the fine overturned, and it's a no-cost jurisdiction, so they're not going to get their costs for appearance on that day. Suffice to say, I would suggest too that if they jump up and down and that, they may well reschedule themselves for a second or third visit, which may be a little bit more thorough.
So, but if they pay the fine, is it on their record?
No, and this is the whole idea when the penalty notice came out, was to be a quicker form of compliance. Now, what happens here, you pay the fine, it is not recorded against your licence. Obviously, Fair Trading have a record in your file, but there is no public record, and it's not deemed to be an offence.
If you challenge it and you lose?
It still doesn't overturn that because they haven't actually taken you to court as an offence.
Well, Greg, so it's all about the paperwork, get it right, and don't worry about fair trading. That's what you're saying?
Correct.
Thank you very much.